So we are picking up on page 8. It's section, I believe, 11L. Yep, 11L, the natural and environmental hazards. Okay, so that's where we're picking up. Natural and environmental hazards, the seller shall, within the time specified in paragraph 3(1), if required by law, deliver to buyer the earthquake guide and environmental hazards booklet for all residential property with 1 to 4 units, and any manufactured or mobile home built before January 1st, 1960, fully complete, and deliver the residential earthquake risk disclosure statement. And even if exempt from obligation to provide a NHD, disclose if the property is located in an earthquake fault zone, seismic hazard zone, and disclose any other zones as required by law and provide other information required for those zones. So that all gets taken care of, just so everybody knows, with the NHD report. If you employ the help of a third-party provider for that natural hazard zone disclosure report, all of that stuff is covered in that NHD report, except for the questionnaire, but there's usually links in those NHD reports for all the environmental hazards book, the earthquake hazards book, the lead-based paint, protecting your family from lead, all those things that you're supposed to provide to the buyer, all that should be in that NHD report. It's always a good practice, though, that if you have like a disclosures IO file, home light listing management file, or glide file with all the disclosures, separate those booklets out and put them in there separately. So if there's actually a record that they received, not just a hyperlink of those copies, but that the buyer actually received a copy of the actual booklets themselves. That earthquake one is only for if the property was built before January 1st, 1960. So if it was built in any time before a 1960 number. Okay, M is known material facts. The seller shall, within the time specified in 3(1), disclose known material facts and defects affecting the property, including but not limited to known insurance claims within the past 5 years, or provide buyer with permission to contact lender to get such information. That would be the CAR form ARC, and make any and all other disclosures required by laws. Okay, that's 11M, known material facts. That's where I like that disclosure information advisory for my seller, because it does a good job outlining exactly what their disclosure requirements are for the transaction. Does anybody have questions about L or M in section 11? If you're doing like a disclosures IO, Heather's question was put the booklets where, and the answer is, and if you had like a disclosures IO file or something for a buyer to review, like as a listing agent, I would separate out all of those disclosure booklets, the protecting your family from lead and the earthquake hazards book, and put them separately inside of there rather than just including a hyperlink. Okay. Section 12 is the buyer's investigation of property and matters affecting the property. The buyer shall, within the time specified in paragraph 3L3, remember this is all referencing that first grid on the first 3 pages, have the right at buyer's expense unless otherwise agreed to conduct inspections, investigations, tests, surveys, and other studies. Buyer's investigations. Buyer investigations include, but are not limited to, inspections regarding any physical attributes of the property or items connected to the property, such as a general home inspection, an inspection for lead-based paint and other lead-based paint hazards, an inspection specifically for wood-destroying pests and organisms. Any inspection for wood-destroying pests and organisms shall be prepared by a registered structural pest control company, shall cover the main building and attached structures, may cover detached structures, shall not include water tests of shower pans on upper level units unless the property owner below the shower consent. So that doesn't include like a regular single family home. It's talking like condos there where you don't own the lower unit, okay? Shall not include roof coverings. And if the property is a unit in a condominium or other common interest subdivision, the inspection shall include only the separate interest and any exclusive use areas being transferred, and shall not include common areas, and shall include a report, pest control report, showing the findings of the company, which shall be separated into sections for evident infestation or infections, which is section 1, and conditions likely to lead to infestation or infection, which would be section 2. And then any other specific inspections of the property condition of the land and improvements. Number 2 is all buyer investigations such as insurance not specified above. See buyer's inspection advisory CAR form BIA for more information. That's included with this purchase agreement at the end. And a review of reports, disclosures, and information prepared by or for seller and delivered to buyer pursuant to paragraph 3, 10, 11, and 14A. So that section there is just the buyer's investigations include. So it's those physical inspections, it's review of reports, disclosures, information prepared by the seller. It covers all of that information. Okay. Any questions about section B or A? C is without the seller's prior written consent, buyer shall neither make nor cause to be made invasive or destructive buyer investigations, except for minimally invasive testing required to prepare a pest control report, which shall not include any holes or drilling through stucco or similar material, or inspections by governmental building or zone inspectors or government employees unless required by law. So what that means is that you're not going to do damage as part of your inspections. You can't pull back the carpet as part of your inspections to see if there's hardwood underneath there because that unstretches the carpet. It is okay for the pest inspector to take their poker around and test the wood to see if it's rotten. That's what that was clarifying. But don't poke holes through the stucco or similar substance. Okay. The seller shall make the property available for all buyer investigations. Seller is not obligated to move any existing personal property. Seller shall have water, gas, electricity, and all operable pilot lights on for buyer's investigation and through the date of possession is delivered to buyer. So keep that in mind right there because that's a really important thing. The utilities are supposed to be on until possession is delivered to the buyer, not when they're done with inspections. Okay. Buyers shall, by the time specified in paragraph 3L3, complete buyer investigations and satisfy themselves as to the condition of the property and either remove the contingency or cancel this agreement. And 2 is by the time specified as it to the condition of the property and either remove, by the time specified in paragraph 3L3, I skipped back up a line, I apologize, or 3 days after receipt of any investigation report, whichever is later, give seller at no cost complete copies of all such reports obtained by the buyer, which obligations shall survive the termination of this agreement. This delivery of investigation reports shall not include any appraisal except an appraisal received in connection with an FHA or VA loan. So they've clarified this very nicely. I like how they rewrote this paragraph. You are required within 3 days of receiving those inspection reports to provide a copy to the seller. The inspection reports do not include the appraisal unless it's a FHA or VA appraisal, at which point the seller has a legal right to have a copy of that appraisal. Not conventional. Okay. And the reason being is that if we cancel on the buyer with an FHA or VA loan, that appraisal is going to float along with that address. And so future potential buyers or their lenders will have access to those appraisals and see the appraised value. So if the appraisal came in low, it's going to continue to be an issue for you. Or if there were repairs noted, it's going to continue to be an issue for you. Okay. E is buyer indemnity and seller protection for entry upon property, right? Buyer shall keep the property free and clear of liens, repair all damage arising from buyer investigations, and indemnify and hold seller harmless from all resulting liability claims, demands, damages, and costs. Buyer shall carry or buyer shall require anyone acting on buyer's behalf to carry policies of liability, workers' compensation, and other applicable insurance, defending and protecting seller from liability for any injuries to persons or property occurring during the buyer investigations or work done on the property at buyer's direction prior to the close of escrow. The seller is advised that certain protections may be afforded to seller by recording a notice of non-responsibility, that's your CAR form NNR, for buyer investigations and work done on the property at buyer's direction. Buyer obligations under this paragraph shall survive the termination of this agreement. So if the buyer has negotiated that they're going to complete repairs prior to the close of escrow to satisfy a condition of the loan that the seller didn't want to do, it's probably in your best interest to have that NNR completed, that seller's notice of non-responsibility, saying that it's not the seller's obligation to pay that bill if the buyer cancels. We also usually don't allow work to begin, whether the seller is paying for it or the buyer is paying for it, until all contingencies have been removed. I want that buyer trapped in there if I'm going to spend money on it as a seller, and especially if I'm the buyer. Any questions about section 12? If an inspector or the buyer damages the property during inspections, that is the buyer's responsibility to make sure it gets remedied. Section 13 is title investing. Buyer shall, within the time specified in 3N1, just so everybody knows, we're kind of moving into the boring part of the contract now. Title investing, the buyer shall, within the time specified in 3N1, be provided with a current preliminary report by the person responsible for paying for the title report and paragraph 3Q8. In paragraph 3Q8, if the buyer is responsible for paying, buyer shall act diligently and in good faith to obtain such preliminary report within the time specified. The preliminary report is only an offer by the title insurer to issue a policy of title insurance and may not contain every item affecting title. The company providing the preliminary report shall, prior to issuing a preliminary report, conduct a search of the general index for all sellers except banks and other institutional lenders selling properties they acquire through foreclosure or REOs, corporations, and governmental entities. Title is taken in its present conditions, subject to all encumbrances, easements, covenants, conditions, restrictions, rights, and other matters, whether of record or not, as of the date of acceptance, except for monetary liens of record, unless buyer is assuming those obligations or taking the property subject to those obligations and those matters to which the seller has agreed to remove in writing. For any lien or matter not being transferred upon sale, seller will take the necessary action to deliver title free and clear of such lien or matter. Seller shall, within the 7 days after request, give escrow holder necessary information to clear title. Seller shall, within the time specified in 3N1, disclose to buyer all matters known to seller affecting the title, whether of record or not, right? Any liens, encumbrances, mechanical liens, anything that might affect the title of the property, potential lawsuits, anything like that falls underneath that category. If buyer is a legal entity and the property purchase price is at least $300,000 and the purchase price is made without a bank loan or similar form of external financing, a geographic targeting order, a GTO issued by the Financial Crimes Enforcement Network, the U.S. Department of Treasury requires title companies to collect and report certain information about the buyer, depending on where the property is located. Buyer agrees to cooperate with the title company's effort to comply with the GTO. F is buyer shall, after the close of escrow, receive a recorded grant deed or any other conveyance document required to convey title or for stock cooperative or long-term lease, an assignment of stock certificate, or the seller's leasehold interest, including oil, mineral, and water rights if currently owned by the seller. Title shall vest as designated in buyer's vesting instructions. The recording document shall contain buyer's post-closing mailing address to enable buyer's receipt of the recorded conveyance document from the county recorder. The manner of taking title may have significant legal and tax consequences. Consult an appropriate professional. We are not the appropriate professional to advise somebody on how to take title to the property. So never advise your buyers how they should take title to the property. You can have them connect up with title and escrow, who also won't tell them how, but they can actually explain the different ways to hold title. And they actually have a little cheat sheet paper that they can give you that walks them through the different manners in which you can hold title and kind of explains them as well. Okay. Any questions about section 13, A through F? Just making sure I didn't miss anything before we moved on. Oh, there is no little note before I move on from that page. I do not believe that there is any clause inside this residential purchase agreement that addresses the seller's purchase of replacement property. So if the transaction is contingent on the seller purchasing replacement property, we want to make sure that we include that as a counter offer or an addendum to the offer. So put it out there ahead of time so that your buyers are aware of it and can include it with their offer to eliminate the counter offer process. But make a little note of that, because at least what we've covered so far, and I have a note that there's no SPRP clause, seller's purchase of replacement property.
Oh, that's a big deal.
That is.
SPRP. Okay. Big deal. All right.
Moving on.
Section G, the buyer shall receive an Alta, Cialta homeowner's policy title of insurance or equivalent policy of title insurance if applicable to the title, type of property and buyer. Escrow holder shall request this policy. If the homeowner's policy of title insurance is not offered, buyer shall receive a CLTA standard coverage policy unless buyer has chosen another policy and instructed escrow holder in writing of the policy chosen and agreed to pay any increase in cost. Buyer shall consult with the title company about availability and difference in coverage and cost between any ALTA and CLTA homeowner's policy and a CLTA standard coverage policy and other title policies and endorsements. Buyer shall receive notice from the title company on its preliminary title report of the type of coverage offered. If buyer is not notified on the preliminary title report, buyer will receive the policy as specified in this paragraph. And that is the end of section 13, title and escrow. Any questions about paragraph G? All right, time periods and removal of contingencies, cancellation rights. The following time periods may only be extended, altered, modified, or changed by mutual written agreement. Any removal of contingencies or cancellation under this paragraph by either the buyer or seller must be exercised in good faith and in writing. That would be on your CAR form CR for contingency removal or CC for the cancellation of contract. A is the seller delivery of documents. The seller shall within the time specified in paragraph 3(1) deliver to buyer all reports, disclosures, and information for which the seller is responsible as specified in paragraphs 9B, 6, 10, 11A, 11B, 11C, 11D, 11H, 11K, 11L, M, 13A, and 13D. That all references back to all those other paragraphs that we've talked about where it outlines all the statutory disclosures and the NHD and all those fun things. Buyer review of documents, repair request, contingency removal, or cancellation. The buyer has the time specified in paragraph 3 to perform buyer investigations, review all disclosures, reports, lease documents to be assumed by the buyer pursuant to paragraph 9B6 and other applicable information which the buyer receives from seller, and approve all matters affecting property, and deliver to seller signed copies of statutory and other disclosures delivered by seller in accordance with paragraph 11. Okay, buyer may within the time specified in paragraph 3L3 request that the seller make repairs or take any other action regarding the property. That would be a CAR form RR, or the request for repairs. Seller has no obligation to agree or respond to the buyer's request on the CAR form RR or the RRRR, which is the seller's response to the buyer's repair request. So if you've noted that they don't have to agree to the repairs and they don't even have to respond officially. Okay. If you're a KW agent, I highly recommend that you respond to the repair request because I just feel like it's bad manners not to. If the seller does not agree or does not respond, buyer is not contractually entitled to have the repairs or other requests made and may only cancel based on contingencies in this agreement. The buyer shall, by the end of time specified in paragraph 3L, or is otherwise agreed, deliver to seller a removal of the applicable contingency or cancellation of this agreement. That would be that CAR form CR or CC. However, if any report, disclosure, or information for which the seller is responsible other than those specified in paragraph 11A or 11B is not delivered within the time specified in paragraph 3(1), then the buyer has 5 days after delivery of such items or the time specified in paragraph 3L, whichever is later, to deliver to seller a removal of the applicable contingency or cancellation under this agreement. If delivery of any report occurs after a contractual contingency pertaining to that report has already been waived or removed, the delivery of the report does not revive the contingency, but there may be a right to terminate for subsequent or amended disclosures under paragraph 11G. Okay, so make sure you have everything in hand before you remove that inspection investigation contingency, is basically what it's saying there. However, If the seller comes back and goes, oh, whoops, I've got an amendment to the SPQ or the TDS after you've removed that contingency, it doesn't revive the contingency, but you may have the ability to cancel within 3 or 5 days, depending on how you received it, of receiving that document if the buyer objects to the information in that document. Okay, so those only fall under certain areas where it's material facts about the property. Continuation of contingency. Even after the end of the time specified in paragraph 3L and before seller cancels, if at all pursuant to paragraph 14C, the buyer retains the right in writing to either remove the remaining contingencies or cancel this agreement based on remaining contingency. Once the buyer's written removal of all contingencies is delivered to the seller, seller may not cancel this agreement pursuant to paragraph 14C1. Please keep in mind your buyer has to remove the contingency and deliver copies of all the signed disclosures back to the seller as part of this time period. Okay, it's not just removal of a contingency, it's actually returning the documents, or the seller can issue a notice to perform for the removal of those documents and cancel the agreement. Don't give the seller a reason to cancel unless you want them to. Seller right to, any questions about B? Everybody's so quiet today. All right, C, seller right to cancel. The seller right to cancel buyer contingencies. If by the time specified in this agreement, buyer does not deliver to seller a removable of the applicable contingency or cancellation of this agreement, then seller, after first delivering to buyer a notice to perform on the CAR form NBP, notice to buyer to perform, may cancel this agreement. In such event, the seller shall authorize the return of the buyer's deposit except for fees incurred by the buyer. Okay, so if the seller cancels because the buyer hasn't removed the contingency, they issue the notice to perform right here. It tells the seller they're going to have to release that deposit. Seller's right to cancel buyer contract obligations. Seller, after first delivering to buyer a notice to buyer to perform, may cancel this agreement if by the time specified in this agreement, buyer does not take the following action or actions. Deposit funds as required by paragraph 3D1 or 3D2, or if the funds deposited pursuant to paragraph 3D1 or 3D2 are not good when deposited. Deliver updated contact information for buyer's lender as required by paragraph 5C3. Deliver a notice of FHA or VA cost or terms, if any, as specified in paragraph 5C4, that's on the CAR form RR. So we no longer use the FVA form, it's now the CAR form RR. It's just on the regular repair requests. Deliver verification or a satisfactory verification if seller reasonably disapproves of the verification already provided as required by paragraphs 5B or 6A. Deliver a letter as required by paragraph 6B. So that's all falling underneath the lender pre-approval and the loan application process. In writing, assume or accept leases or liens as paragraph 8G. Return statutory or other disclosures required by paragraph 11F. Cooperate with title company's effort to comply with the GTO requirement by paragraph 13E. Sign or initial separate liquidated damages for an increased deposit as required by paragraph 5A2 and 29. Provide evidence of authority to sign in a representative capacity as specified in paragraph 28, or perform any additional buyer contractual obligations included in this agreement. In such event, the seller shall authorize the return of the buyer's deposit, except for fees incurred by the buyer and other expenses already paid by escrow holder pursuant to this agreement prior to the seller's cancellation. So there's all the reasons the seller can cancel the contract. I feel like they drew them up and made them much more clear and plain and easier to understand. Seller's right to cancel seller contingencies. Number 3, the seller may cancel this agreement by good faith exercise of any seller contingency included in this agreement or otherwise agreed, so long that the contingency has not already been removed or waived in writing. Buyer's right to cancel. The buyer right to cancel seller contingencies if by the time specified in this agreement, the seller does not deliver to buyer a removal of the applicable contingency or cancellation of this agreement, then buyer, after first delivering to seller a notice to perform on the CAR form NSP, notice to seller to perform, may cancel this agreement. In such event, seller shall authorize the return of buyer's deposit except for fees incurred by buyer and other expenses already paid by escrow holder pursuant to this agreement prior to buyer's cancellation. buyer's right to cancel seller contract obligations if by the time specified, the seller has not delivered any items specified in paragraph 3(1), or the seller has not performed any seller contractual obligation included in this agreement by the time specified. The buyer, after first delivering to a seller a notice to seller to perform, may cancel this agreement. So that has to do with all of the statutory disclosures and the HOA information and leased or liened items. So all that stuff's supposed to be delivered by the seller. If it's not, the buyer doesn't have to just sit around and wait, they can cancel. You have to issue that notice to perform first. Buyer right to cancel buyer contingencies. Buyer may cancel this agreement by good faith exercise of any buyer contingency included in paragraph 8 or otherwise agreed, so long as that contingency has not already been removed in writing. There's your buyer contingencies. The notice to buyer or seller to perform is in section E. The notice to buyer to perform or notice to seller to perform shall be in writing, signed by the applicable buyer or seller, and give the other party at least 2 days after delivery or until the time specified in the applicable paragraph, whichever occurs last, to take the applicable action. A notice to the buyer to perform or notice to the seller to perform may not be delivered earlier than 2 days prior to the scheduled performance day to remove a contingency or cancel this agreement to meet an obligation specified in paragraph 14, whether or not the scheduled performance day falls on a Saturday, Sunday, or legal holiday. If a notice to perform or notice to seller to perform is incorrectly delivered or specifies a time less than the agreed time, the notice shall be deemed invalid and void, and the seller or buyer shall be required to deliver a new notice to the buyer to perform or notice to the seller to perform within the specified time frame. So
Twist me up every time.
you can give the seller or the buyer 5 days to perform as long as you're not serving it more than 2 days before that is actually due. Right? And if it's due on a Sunday, it's technically due on a Monday. So you can't deliver it until like Saturday. We can't deliver it on Friday because now it's invalidated it because the technical day of performance is Monday. Okay? We don't want to invalidate our notices to perform. And just because you serve a notice to perform does not mean you have to cancel. It just is to spur action by the other party in most cases.
Does this happen often?
It can.
Some people make it part of their system.
Some people make it part of their system.
I haven't seen many, but they do. That's always me.
It does. It's like seeing a cop as you're driving down the highway, even if you're not speeding.
Yeah. Right.
Okay. Section F is the effect of the removal of contingencies. The removal of buyer contingencies. If buyer removes any contingency or cancellation rights unless otherwise agreed to, buyer shall conclusively be deemed to have completed all buyer investigations and review of reports and other applicable information and disclosures pertaining to that contingency or cancellation right, elected to proceed with the transaction, and assumed all liability, responsibility, and expense for the non-delivery of any reports, disclosures, or information outside of the seller's control, and for any repairs or corrections pertaining to that contingency or cancellation right for the inability to obtain financing. Okay, so if they can't obtain financing, they've already removed that loan contingency, too bad, buyer. If there's something that pops up after their inspection contingency, even after the close of escrow, and they find something else that the inspector missed, that's not on the seller, that's on the buyer, unless we can go back and prove that the seller failed to disclose. But if there's no case of failure to disclose, like nobody knew about it, then it falls on the buyer. Removal of seller contingencies. If the seller removes any contingency or cancellation rights unless otherwise agreed, the seller shall conclusively be deemed to have satisfied themselves regarding such contingency, elected to proceed with the transaction, and given up any right to cancel this agreement based on such contingency. Okay, demand to close escrow. So we have the notice to buyer to perform and notice to seller to perform. In addition to that, we have our demand to close escrow. Before buyer and seller may cancel this agreement for failure of the other party to close escrow pursuant to this agreement, the buyer or seller must first deliver to the other party a demand to close escrow. It's the CAR form DCE. The DCE shall be signed by the applicable buyer or seller and give the other party at least 3 days after delivery to close escrow. The DCE is incorrectly delivered Oh, hold on. After delivery, a DCE may not be delivered any earlier than 3 days prior to the scheduled performance day for the close of escrow. If the DCE is incorrectly delivered or specifies a time less than the above time frame, the DCE shall be deemed invalid and void, and the seller or buyer shall be required to deliver a new DCE. And notice it says 3 days after delivery. So if I deliver it today, it's the same thing with the notice to perform. Today is day 0. It doesn't count as day 1. Tomorrow is day 1. Which would be Friday, Saturday is day 2, Sunday is day 3. Come Monday, we can actually cancel. Well, technically we can't cancel till Tuesday because you can't perform on a Sunday. So if it falls on a Sunday, it rolls to Monday. So you can't actually cancel till Tuesday. So don't ever cancel on a Thursday. You can cancel on a Wednesday. No.
Wednesday,
Cancel on
Thursday,
Monday.
Friday, and Saturday. I mean, they'll have. to
No,
work Saturday night.
then no, because we don't have to perform on a weekend or a holiday, so it still rolls to Mondays. You can't cancel till Tuesday.
Just don't cancel.
So you want to cancel on Monday or Tuesday or Friday.
Oh, we need to make up a song or something.
H is the effective cancellation on deposits. If the buyer or seller gives written notice of a cancellation pursuant to rights duly exercised under the terms of this agreement, the parties agree to sign and deliver mutual instructions to cancel the sale and escrow and release deposits, if any, to the party entitled to the funds, less fees and costs paid by escrow holder on behalf of that party, if required by this agreement. And any escrow cancellation fee charged to that party, fees and costs may be payable to service providers and vendors for services and products provided during escrow. A release of funds will require mutual signed release instruction from the parties, judicial decision, or arbitration award. A party may be subject to civil penalty of up to $1,000 for refusal to sign cancellation instructions if no good faith dispute exists as to which party is entitled to the deposited funds. Note, neither agents nor escrow holder are qualified to provide any opinion on whether either party has acted in good faith or which party is entitled to the deposited funds. Buyer and seller are to seek advice of the qualified real estate attorney regarding this matter. Keep this in mind, this little paragraph right here, because this 14H comes in handy a lot with that. The party may be subject to a civil penalty of up to $1,000 for refusal to sign mutual cancellation instructions. A lot of times if you cite that, it gets the document signed a lot faster if you're having problems getting one signed. Usually everybody knows where the deposit should go and that we're canceling and life goes on. And sometimes they just like to delay because they're hurt. It becomes emotional. Okay. Hold on, I'm just double checking my notes. Bottom. Oh, keep in mind that if the deposit falls underneath the small claims limit for small claims court and the deposit isn't being released, you can take the other party to small claims court for that award. However, you may still be obligated to arbitration in order to get the legal fees reimbursed. Just something. Little side note there. There's mediation. You need to go to mediation. So when we get to that part of the contract, mediation is always required. Arbitration is the one that you initial to. So in order to win the legal fees, oftentimes you have to still go through the mediation process.
Consult your CPA, sir.
Consult a real estate attorney. All right. 15, repairs. All right, repairs shall be completed. We're on 15. Repairs shall be completed prior to final verification of condition unless otherwise agreed. Keep in mind that on this new purchase agreement, it says the final verification of property condition is to be completed 5 days prior to the close of escrow, not within 5 days, but actually 5 days prior, which means all the repairs should be completed 5 days prior to close. If those repairs aren't going to be completed 5 days prior to close, you probably need an amendment to the contract, an AEA, extending that time frame to complete those repairs and changing the final verification date to match with when the repairs will be completed. Just throwing that out there. unless otherwise agreed. Repairs to be performed at seller's expense may be performed by seller or through others, provided that the work complies with applicable law, including governmental permit, inspection, and approval requirements. Repairs shall be performed in a good, skillful manner with materials of quality and appearance comparable to existing materials. Buyer acknowledges that exact restoration of appearance or cosmetic items following all repairs may not be possible. Sellers shall obtain invoices and paid receipts for repairs performed by others. Or prepare a written statement indicating the repairs performed by seller and the date of such repairs, and provide copies of invoices and paid receipts and statements to the buyer prior to the final verification of condition. Okay, so unless you specify in your repair request that you want it done by a licensed contractor or a licensed electrician or a licensed plumber, the seller can complete that work or decide a handyman or whoever can complete the work as long as it's done in a good, skillful manner. Okay, with materials that are similar to what was there existing. And it's okay as a buyer's agent to request copies of receipts, a statement of what was done and on what days it was done by the seller. Any of that information is completely acceptable, and you should have it before you do your final verification of property condition so that you can verify it's actually been done.
Or if you get pushed, if you get pushed out, like in my case, we negotiated, and then the repair was scheduled after we moved in.
You want to try to
Unheard
avoid
of?
that. No, you can do that.
Huh?
You can
Yeah,
do that.
Yeah, you say you want to avoid that, huh?
Well,
Yeah.
sometimes
Mhm.
You want
it
to,
happens.
sometimes it happens, especially now we've got shorter escrows. We're trying to get stuff done and longer time periods for scheduling the work. As long as all parties are involved, we have it in writing, who's taking care of the payment and when it's going to be done. It's okay, but we try to get things done within the escrow period. Final verification of condition. The buyer shall have the right to make a final verification of property condition within the time specified in paragraph 3J, not as a contingency of the sale, but solely to confirm that the property is maintained pursuant to paragraph 7B. Repairs have been completed as agreed, and seller has complied with the seller's obligations under this agreement. You can't stop the sale of the property if those items aren't done. You can take them to small claims court.
Yeah.
I mean, you can try to
And you pay
delay.
those fees.
Yeah, you can try to delay, but you can take them to small claims court if the repairs aren't done, or if they haven't completed, the repairs aren't done, or the property was damaged. We can still close escrow.
But they don't have the right to back out of that.
They don't have the right to back out at that point. Prorations of property tax. Does anybody have any questions about sections 15 or 16 or 14? All right. 17, prorations of property taxes and other items. Unless otherwise agreed, the following items shall be paid current and prorated between the buyer and seller as of close of escrow. Real property taxes and assessments, interest, seller rental payments, HOA regular assessments due prior to the close of escrow, premiums on insurance assumed by buyer, payments on bonds and assessments assumed by buyer, and payments on Melrose and other special assessment direct bonds and assessments that are now a lien. Seller shall pay any HOA special or emergency assessments due prior to the close of escrow. The following items shall be assumed by buyer without credit towards the purchase price. Prorated payments on Melrose and other special assessment direct district bonds and assessments, and HOA special or emergency assessments that are due after the close of escrow. Property will be reassessed upon change of ownership. Any supplemental tax bills delivered to the escrow holder prior to closing shall be prorated and paid as followed. For the periods after the close of escrow by buyer, and for the periods prior to the close of escrow by seller. See CAR form SPT or SBSA for further information. Seller agrees all service fees, maintenance costs, and utility bills will be paid current up to and through the close of escrow. So that includes the close of escrow date because it's through the close of escrow. Tax bills and utility bills issued after close of escrow shall be handled directly between the buyer and seller. Prorations shall be made based on a 30-day month, even if it's February and there's less than 30 days, or August and there's more than 30 days. Any questions about prorations of property taxes and other items? The good news is title and escrow take care of that. We don't have to do a whole lot. We just need to know the information and where to find it. Brokers and agents, compensation, seller or buyer, or both as applicable, agree to pay compensation to broker as specified in a separate written agreement with the broker that the seller or buyer, written agreement between the broker and that seller or buyer. Compensation is payable upon close of escrow, or if escrow does not close as otherwise specified in the agreement between the broker and that seller or buyer. Scope of duty. Buyers and sellers acknowledge that and agree that the agent does not decide what price the buyer should pay or seller should accept, does not guarantee the condition of the property, does not guarantee the performance, adequacy, or completeness of inspection services, products, or repairs provided or made by seller or others, does not have an obligation to conduct an inspection of common areas or areas off-site of the property, shall not be responsible for identifying defects on the properties in common areas or off-site unless such defects are visually observable by an inspection of reasonably accessible areas of the property and are known to the agent. Shall not be responsible for inspecting public records or permits concerning the title or use of property. Shall not be responsible for identifying the location of boundary lines or other items affecting title. Multiple listing service, advertisements, flyers, or other promotional material. Oh, wait, hold on. Affecting title. I skipped a line. Shall not be responsible for verifying square footage, representation of others, or information contained in investigation reports, multiple listing service, advertisement, flyers, or promotional materials. Shall not be responsible for determining the fair market value of the property or any personal property included in the sale. Shall not be responsible for providing legal or tax advice regarding any aspect of the transaction entered into by buyer or seller, and shall not be responsible for providing other advice or information that exceeds the knowledge, education, and experience required to perform real estate licensed activity. Buyer and seller agree to seek legal, tax, insurance, title, and other desired assistance from the appropriate professionals. There you go. Any questions about section 18? Keep in mind here, though, it did say that shall not be responsible for providing other advice, information that exceeds the knowledge, education, and experience required to perform real estate license activity. Not that you have, like you may be a licensed contractor, so you may have additional information. That's not part of your duty as a real estate agent. Keep that separate from your real estate duties. Only go over the information that's required of you as a licensed realtor. 19 is our joint escrow instructions to escrow holder. I'm not going to cover this in detail because really what this just outlines to the escrow holder is that they are the neutral party in charge of the transaction. They handle the monies, they prorate everything, they do all of that. So we're just going to skip that.
Sometimes they find extra money for you.
Oh, here, there is something new. I'm a liar. I'm going to cover one little section of the escrow holder. It's section E. So it is 19E is new. The buyer and seller acknowledge the escrow holder may require invoices for expenses under this agreement. Buyer and seller will, upon request by escrow holder within 3 days or within sufficient time to close escrow, whichever is sooner, shall provide any such invoices to escrow holder. Escrow does that. We do it. It's now part of the contract. It's not like a new action. It's just new in the contract. All right, section 20 is the selection of service providers. Agents do not guarantee the performance of any vendors, service, or product providers, whether referred by agent or selected by buyer, seller, or other person. Buyer and seller may select any providers of their own choosing. Okay. 21 is the multiple listing service or MLS. Agents are authorized to report to the MLS that an offer has been accepted and upon close of escrow, the sales price and other terms of this transaction shall be provided to the MLS to be published and disseminated to persons and entities authorized to use the information on terms approved by the MLS. Buyer acknowledges that any pictures, videos, floor plans, collectively images, or other information about the property that has been or will be inputted into the MLS or internet portals or both at the instruction of the seller or in compliance with MLS rules will not be removed after the close of escrow. California Civil Code 1088 requires the MLS to maintain such images and information for at least 3 years, and as a result, they may be displayed or circulated on the internet, which cannot be controlled or removed by seller or agents, and seller, seller's agent, buyer's agent, and MLS have no obligation or the ability to remove such images or information from the internet.
People really ask about that too.
They do.
Mhm.
Why? Because they don't want
They
their
don't want
property on
their,
there.
yeah.
They don't want people to see the inside of their house.
And it's already public.
It is
Yeah.
what it is. I tell my people, listen, 2 years from now, you can find your front door on a poster. There's
Yeah.
nothing you
Can
can
do about it.
Good.
Attorneys' fees and costs and any action proceeding or arbitration between buyer and seller arising out of this agreement, the prevailing buyer or seller shall be entitled to reasonable attorney fees and costs from the non-prevailing buyer or seller, except as provided in paragraph 30A. Assignment, the buyer shall have the right to assign all of buyer's interest in this agreement to buyer's own trust or to a wholly owned entity by buyer, entity of buyer that is in existence at the time of such assignment. Otherwise, buyer shall not assign all or any part of buyer's interest in this agreement without first having obtained a separate written consent of the seller to a specified assignee. So you can assign it to a trust, right? We can put our names on the contract and then actually close in the name of the trust. Totally okay. You don't have to have the seller's permission, but anybody outside of that needs to have seller's permission. Buyer shall disclose, prior to any assignment, buyer shall disclose to seller the name of the assignee and the amount of any monetary consideration between buyer and assignee. Buyer shall provide assignee with all the documents related to this agreement, including but not limited to the agreement and any disclosures. If assignee is a wholly owned entity or trust of the buyer, that assignee does not need to re-sign or initial all the documents provided, whether or not an assignment requires the seller's consent. At the time of assignment, assignee shall deliver the letter from assignee's lender to the assignee that the assignee is pre-qualified or pre-approved as specified in paragraph 6B. Should assignee fail to deliver such letter, seller, after first giving assignee a notice to buyer to perform, shall have the right to terminate the agreement. Buyer shall, within the time specified in paragraph 3K, deliver any request to assign this agreement for seller's consent. If the buyer fails to provide the required information within this time frame, seller's withholding of consent shall be deemed reasonable. Any total or partial assignment shall not relieve buyer of buyer's obligation pursuant to this agreement unless otherwise agreed to by seller. It's the CAR form AOAA, assignment of agreement. And that goes if you're adding a buyer to the contract or if you're changing the buyer completely. That all falls under that AOAA. And remember that now in the grid, we have a time frame for which we have the ability to do that. You can't do it on day 30 anymore. I believe the default is 17 days. Okay. Equal housing opportunity. The property is sold in compliance with federal, state, and local anti-discrimination laws. Definitions and instructions. The following words are defined in this agreement and shall be indicated by an initial capital letters throughout the agreement and have the following meaning whenever used. Let me check and see if there's any changes on the definitions. I don't think there are. Oh. Hold on. Oh, I know. So there is a difference in here as we go through the definitions. So we'll go through them all. Acceptance means the time the offer or final counter offer was fully executed in writing by the recipient party and is delivered to the offering party or that party's authorized agent as indicated on the form. Agent means the broker, salesperson, broker associate, or any real estate licensee licensed under the brokerage firm identified in paragraph 2B. Agreement means this document or any other counter offers or any incorporated addendum or amendments collectively forming the binding agreement between the parties. Addendum and amendments are incorporated only when signed and delivered by all parties. As is condition, the seller disclosed no material facts and defects as specified in this agreement. Buyer has the right to inspect the property and within the time specified, request seller make any repairs or take corrective actions or exercise any contingency cancellation rights in this agreement. Seller is only required to make the repairs specified in this agreement or as otherwise agreed. Authorized agent means an individual real estate licensee specified in the real estate broker section. CAR form means the most current version of the specific form referenced or another comparable form agreed to by the parties. Close of escrow, including COE, means the date the grant deed or other evidence of transfer of title is recorded for the real property, or the date of delivery of a document evidencing that transfer of title or non-real property transaction. Copy means by any means, including photocopy, fax, or electronic. Counting days is done as follows. Otherwise agreed, unless otherwise agreed. 1, the first day after an event is the first full calendar date following the event and ending at 11:59 p.m. For example, if a notice to buyer to perform is delivered at 3 p.m. on the 7th calendar day of the month, or acceptance of a counteroffer is personally received at 12 noon on the 7th calendar day of the month, then the 7th day is day 0. For the purpose of counting days to respond to the notice to buyer perform, or calculating the close of escrow date or contingency removal dates. And the 8th of the month is day 1 for those same purposes. All calendar days are counted in establishing the first day after the event. All calendar days are counted in determining the date upon which performance must be completed, ending at 11:59 on the last day for performance. Scheduled performance day. After acceptance, if the scheduled performance day for any act required by this agreement, including close of escrow, lands on a Saturday, Sunday, or legal holiday, the performing party shall be allowed to perform on the next day that is not a Saturday, Sunday, or legal holiday, allowable performance day, and ending at 11:59 p.m. For the purposes of close of escrow, any day that the recorder's office in the county where the property is located is closed, the close of escrow shall occur on the next day when the recorder's office in that county is open. Close of escrow is considered day 0. For the purpose of counting days, seller is allowed to remain in possession if permitted by this agreement. Everybody understand all these up to this point? They did a good job re-clarifying the days. I appreciate that. Day or days means calendar day or days. However, delivery of deposit to escrow is based on business days. So
There's always a however.
there's always a however. Delivery of documents unless otherwise agreed to means that this shall be effective upon personal receipt of the document by buyer, seller, or authorized agent. Personal receipt means a copy of the document, or as applicable, a link to the document, is in the possession of the party or authorized agent, regardless of delivery method used, i.e. email, text, or other, or an electronic copy of the document as applicable. Link to the document has been sent to any of the designated electronic delivery addresses specified in the real estate broker section on page 16. After acceptance, agent may change the designated electronic delivery address for that agent by in writing delivering notice of a change to the designated electronic delivery address to the other party. Links could be, for an example, to a Dropbox, Google Drive, or other functionally equivalent program. If the recipient of a link is unable or unwilling to open the link or download the documents, or otherwise prefers delivery of the documents directly, receipt of a link shall notify recipient of a link shall notify the sender in writing within 3 days after delivery of the link, CAR form RFR. In such case, delivery shall be effective upon delivery of the document and not the link. Failure to notify sender within the time specified above shall be deemed consent to receive and buyer opening the document by link. Phew. What this means is that you no longer have to physically receive a copy of the signed purchase contract back to be accepted. The sender just has to have proof that they electronically sent it to you. So they can send it at 11:59 p.m. and have that count as day 0.
And have what?
That count as day 0. So oftentimes, because you have to receive it physically by the other party, I just won't open my email after 6 p.m. because I don't want that to count as any sort of delivery day of day 0. And now, as long as they've sent it, it counts. Unless you want to fill out that RFR, stating that you must receive documents personally. Electronic copy, and it can be a link, right? It doesn't have to be the physical copy anymore. It can be a PDF. It can be a link to the Disclosures IO site. It can be a link to your Google Drive, whatever that would be. Electronic copy or electronic signature means as applicable, an electronic copy or signature complying with the California law. Buyer and seller agree. No, don't do that. How dare you? It's all right. You can do this. Hold on. It logged me out because I didn't touch it enough. Hold on. I think I have to do this. Yeah. All right. Zooming back to where we were at, 12, 13. All right, electronic copy. Buyer and seller agree that electronic means will not be used by either party to modify or alter the content or integrity of this agreement without the knowledge and consent of the other party, right? So if there's changes to a document done electronically, it needs to be initialed by all parties. All right, law means any law, code, statute, ordinance, regulation, rule, or order which is adopted by a controlling city, county, state, federal, legislative, judicial, or executive body or agency. Legally authorized signer means an individual who has the authority to sign for the principal as specified in paragraph 32 or paragraph 33. Otherwise agreed means the agreement in writing signed by both parties and delivered to each. Repairs mean repairs including pest control, alterations, replacements, modifications, or retrofitting of the property provided for under this agreement. Sign or signed means either a handwritten or electronic signature on an original document, copy, or counterpart. What counterpart means is that on like a statewide buyer and seller agreement, the buyer may sign one copy, the seller may sign another copy. As long as the form's the same, we're good to go. Okay, they don't have to sign on the same piece of paper. Okay. Otherwise agreed, repair, signed. Okay, we're moving on. Any questions about section 25? 26, terms and conditions of offer. This is an offer to purchase the property and the terms and conditions herein. The individual liquidated damages and arbitration of disputes paragraphs are incorporated into this agreement if initialed by all parties or if incorporated by mutual agreement and a counter offer or addendum. If at least one, but not all parties initial, a counter offer is required until agreement is reached. So everybody has to be in agreement whether we agree to or don't agree to liquidated damages and the arbitration of disputes. Okay. Seller has the right to continue to offer the property for sale and to accept another offer at any time prior to notification of the acceptance and to market the property for backup offers after acceptance. When you market the property for backup offers after acceptance, it means you're saying contingent show, not active. Just in the MLS, don't leave it as active. Okay. The parties have read and acknowledged. I lost my place. The parties have read and acknowledged a receipt of a copy of the offer and agreed to the confirmation of agency relationships. If this offer is accepted and buyer subsequently defaults, the buyer may be responsible for payment of broker's compensation. This agreement and any supplement, addendum, or modification, including any copy, may be signed in two or more counterparts, all of which shall constitute one and the same writing. By signing this offer or any document in the transaction, the party signing the document deems to have read the document in its entirety. Time is of the essence, entire contract and changes. Time is of the essence. All understandings between the parties are incorporated into this agreement. Its terms are intended by the parties as final, complete, and exclusive expression of their agreement with respect to the subject matter and may not be contradicted by evidence of any prior agreement or contemporaneous oral agreement. Everything has to be in writing. If any provision of this agreement is held to be ineffective or invalid, the remaining provisions will nevertheless be given full force and effect. Except as otherwise agreed, this agreement shall be interpreted and disputes shall be resolved in accordance with the laws of the state of California. Neither this agreement or any provision may be extended, amended, modified, or altered or changed except in writing by the seller and the buyer. Legally authorized signer. Wherever the signature or initials of the legally authorized signer identified in paragraph 32 or 33 appear in this agreement or any related documents, it shall be deemed to be representation in a representative capacity for the entity described and not in an individual capacity unless otherwise indicated. The legally authorized signer represents that the entity for which that person is acting already exists and is in good standing to do business in California, and shall deliver to the other party and escrow holder within 3 days after acceptance evidence of authority to act in that capacity, such as, but not limited to, applicable portion of the trust or certificate of trust, letters, testamentary, court order, power of attorney, corporate resolution, or formation documents of the business entity. Okay. I am going to skip over this section only because I'm at my time frame. We'll come back and revisit this later, but there weren't any real changes to the arbitration and mediation and liquidated damages, except they put little boxes around them to separate them out and make it more clear. So on this one, you're either agreeing or not agreeing to the liquidated damages by initialing 29. 30, you have to agree to. You're agreeing by signing this contract that you agree to mediation. And the arbitration is an optional signature as well. Okay, so liquidated damages, arbitration optional, mediation is mandatory. Okay. The only reason I want to skip down is because the signature part is a little different and I don't feel ready to go write an offer tomorrow and understand this so that we make sure we know what we need to do. So 32 is the expiration of offer. This offer shall be deemed revoked and the deposit, if any, shall be returned to the buyer unless the date and time specified by the date and time specified in paragraph 3C, the offer is signed by a seller and a copy of the signed offer is delivered to buyer or buyer's authorized agent. Seller has no obligation to respond to an offer made. Okay, seller has no obligation to respond to an offer made. You can ask for proof of delivery, right? Proof of that the offer was delivered to the seller for review, but they have no obligation to respond. And that expiration was in part of the grid. Entity for buyers. So this is a change. If you check this box here for section B, it means that it's an entity buyer. If this paragraph is completed, a representative capacity signature disclosure or CAR form RCSD is not required for the legally authorized signers designated below. So we no longer sign this and do a RCSD. We can just fill out all the information here and then have the buyers sign to make their offer. So one is one or more buyers of a trust, corporation, LLC, probate, estate, partnership, holding a power of attorney or blank other. You can check the box for other. So that's your first option. This agreement is being signed by a legally authorized signer in a representative capacity and not in an individual capacity. See paragraph 28 for additional terms. The legal names of the authorized signers are blank. Right? So on the buyer, we're going to put the entity. Here we're putting the legally authorized names, and then on the signature lines, it'll be the names. If a trust, identify buyers as trustee of the trust by a simplified trust name, John Doe co-trustee, Jane Doe co-trustee, or Doe Revocable Family Trust. If the entity is a trust or under probate, the following is the full name of the trust or probate. Case, including case number. So if it's under probate, you're going to put the case number there on that line. Okay. If you check the box, you need to make sure that who you write in who the legally authorized signers are for the entity on line 3. It's 3. Okay. So that's section B. That's only if you were going to use an RCSD. Now it's replaced by this paragraph 32B. Okay. What?
Nice.
It's nice, right? We're eliminating a little, well, we added several pages and then we're eliminating a couple. So we still have more paperwork than before, but less documents.
I
So
got my first offer on this form.
it's nice, right?
It is.
It's much easier to decipher all the information. The RPA has 16 pages. Buyer acknowledges receipt of and has read and understands every page and all attachments that make up the agreement. Buyer's signature, there's where the buyer signs. If the printed name of the buyer, so if the buyer was the John Doe Trust, the printed name of the buyer would show up as the John Doe Trust, and then we would check the little box for printed name of legally authorized signer. That's where we would put John Doe Trustee, right? Title. Or if it was like a president of a corporation, the corporation would show up under the buyer's name. The signer would go there on that bottom section and then their signature. Okay. We can only have 2 or more signers on this contract. Two, not 2 or more. I said 2 or more. You can only have 2 or less. If you have 4 buyers, 2 of them go on the contract, and then you check the little box there at the bottom of 32 for if 2 or more than 2 signers use the additional signature addendum car form ASA, where you list out all the documents we're signing, and then they just sign 1 piece of paper instead of 27 pieces of paper. It really works out to be buyer 3 and 4. Okay. Acceptance, seller warrants that the seller is the owner of the property and has the authority to execute this agreement. Seller accepts the above offer and agrees to sell the property on the above terms and conditions. Seller has read and acknowledges receipt of the copy of this agreement and authorizes the agent to deliver a signed copy to the buyer. Seller's acceptance is subject to the attached counter offer or backup offer addendum or both. Check below. Seller shall return and include the entire agreement with any response. So the entire purchase agreement should go out with the counter offer or the backup offer addendum, and you can do either one there. Okay. So we check those boxes if we need to counter or do a backup offer. If the sellers are entities, it's the same paragraph there that on 33B that we had on 32B that outlines who the entity is and who's signing on that behalf. You fill it out exactly the same way that we talked about on the section above, section B. The RPA has 16 pages. Seller acknowledges receipt of and has read and understands every page and all attachments that make up this agreement. And then the seller sign. And same thing here, if it's an entity, the name of the entity goes on the printed name of seller. We're going to check the box for the printed name of legally authorized signer, put their name there and their title if applicable, and then they're going to sign on the next line. And same thing here, we only put 2 sellers on the purchase contract if we're more than 2 sellers. And this goes for any and every document except for the ASA. There's only 2 signature lines. So we only put 2 people on every document. If we have more than 2 people that's party of the transaction, it always goes on an ASA. So on a purchase contract, you're going to have an ASA that's going to state the RPA, the WFA, the PRBS, the agency disclosure, the California Consumer Privacy Act, the buyer's inspection advisory, right? At the very least. And then they're going to sign that. And then when we get the seller disclosures, we're going to go to the top of that ASA and list out all the seller disclosures. Everybody else signs the actual seller disclosures, and those additional buyers or sellers sign the ASA for that. And so every time we sign something, we're going to have that ASA come into play again. You might have 20 ASAs.
Oh, wow.
If the offer is not accepted, the seller can initial there at the bottom, no counter offer is being made, and this offer was not accepted by seller, and you put in the date. Remember, the seller does not have to respond. Everybody initials the bottom of this page. The next section is the real estate brokers section, where you fill out this last section. It matches the old section, and we're at 1222. So I'm not going to go through this. Oh, I am going to go through this section because under section 5, I'm sorry, I'm a liar. It has the designated electronic delivery addresses. Okay, there's the email and text number of where you will be willing to accept electronic delivery. You're going to put it in there. Okay, so make sure you fill it out completely for your information. Okay, if I was filling this out for my buyer, I'm going to fill out the listing agent's email and text number there so that they acknowledge that that's where they want it, unless it's like counter offered or clarified later on. That way I know that when my buyer, when the seller sends me a counter offer and my buyer signs it, I can send it back to one of those 2 methods and that counts as accepted.
Oh, okay.
Okay, so I'm going to fill out that information just like I would fill out older information on the original contract. Okay, that's the part that changed. There's still a place that you can put when you presented the offer. So even if your seller refuses to respond to an offer, you still want to probably send back page 16 of 16 stating that you presented this offer to the seller on such and such date so that there's no doubt that it was presented, whether the seller decided to respond or not. Okay, and my normal method, if we had multiple offers, we didn't accept any, there were some that were rejected, is to ask them if they wanted the rejection filled out. And now I'd probably default to just asking them if they wanted proof that we presented the offer to the other party and send that back with the initials and the date that it was presented instead of a rejection if we didn't want to officially reject it. Or I didn't want the seller to have to initial more things. Because they have no obligation to respond. Any questions about these last few sections that we kind of flew through to get finished?